everybody. Thank you so much for joining us for this webinar today. I'm Andréa Awoniyi. I'm a family law barrister here at 42BR.
I'm Max Montgomery. I'm also a family barrister here at 42BR.
So this is the last session in our current family law series, and the recordings of the previous ones can be found on our website. Also, just a bit of housekeeping. There is a Q&A box that should be appearing somewhere on your screen. If you have any questions, please do pop them in there. And then at the end of the talk, we will have a bit of time for to answer any questions. But if you are watching this recording after and not live, then please do send in your questions to events@42br.com. And an email containing this recording and the slides will be sent out to you along with a feedback form over the next few days. So we are going to get started today on our talk, which is about case management hearings and how to prepare for success in private children cases. So we're going to start off with Max giving you an overview of case management hearings, talking you through the various hearings. So we've got the FHEDRAs, the PTRs and the DRAs, all of the abbreviations, as well as I will then take us through interim child arrangements and appeals. And then we will have some time towards the end of our webinar where we will just talk through some practical tips and how to best prepare for case management hearings. And at the end, like I said, we will have a time for questions. So please do send your questions as we go, and hopefully we have time to answer those at the end.
Fabulous. Thank you, Andrea, and hello, everyone. Good on you for attending. Well, it's 30 degrees outside. We'll try and keep this as concise as possible. So, as Andrea says, I'm going to give you a bit of an overview of case management hearings. Essentially, I'm going to do the boring stuff. So, talk you through what they are and go through some of the specific case management hearings that we often encounter. And then I will hand it back to Andrea and we'll have a bit of a chat at the end. So, what are case management hearings? Well, a fairly easy question to answer. They are hearings to manage cases. The context in which we're looking at this is within private children law and specifically within Section 8 applications. And to kind of make it even simpler, I'm just thinking about applications for a child arrangements order, but effectively we're dealing with the same stuff, whether it's one of the other applications under Section 8 for a specific issue order or a prohibited steps order. So when we are preparing for these sort of hearings, it is worth bearing in mind what the judge will be thinking about. And that, largely, is the overriding objective. Now, I put it up on screen. You should be familiar with it. I'm not going to read it all out. But I do highlight it because I think in family law, we probably give it a little bit less love than certainly in civil work that I've done in the past. There is more of a focus, I think, on the overriding objective. And I think it's just worth always bearing that in mind. And I say that specifically because Rule 1.4, which follows on from the overriding objective, puts on the court a duty to actively manage cases. So obviously very relevant to case management hearings. Now, Rule 1.42 sets out some examples of what active case management includes. Now that list goes from A to M, so I'm not going to go through those all, but I have picked out a few that are on screen there. Timetabling, identifying the issues, controlling the evidence, helping settlement if possible, and that is always possible. It is usually possible at case management hearings. And one other point which is interesting and which the court must do is deal with as many aspects of the case as it can on one occasion. So that's worth bearing in mind as you prepare for these hearings, and because it's something the judge will be bearing in mind when preparing for the hearings. What I'm effectively going to do now is walk you through Practice Direction 12B, because that sets out what we should be dealing with at case management hearings. And within Practice Direction 12B, there is a reminder of effectively the key principles. It refers back to Section 1 of the Children Act, so that in these hearings, the primary consideration, or the paramount consideration, is the child's welfare. It also reminds us that delay is likely to be prejudicial to the welfare of the child, and the no order principle is set out there as well. So that is worth bearing in mind when preparing for these hearings. So let's look at some of the specific case management hearings we often encounter. So a FHDRA. Practice Direction 12B, as I say, is where we go for this, and it's paragraph 14, which sets out what a FHDRA is. And it is the first hearing. When it is, should be 4 to 5 weeks following the case being issued. The other parties should be given 14 days notice where practicable, or a different period if specified by the court, for example, in the gatekeeping order. And notice is worth thinking about. That can really curtail hearings. And in my experience, that is something that a lot of judges can be very hot on. So worth bearing that in mind as you prepare. The paragraph 14.6 says that the CAFCAS officer shall attend. Now, in my experience, we don't always get the benefit of a CAFCAS officer, but they should be there. Interestingly, paragraph 14.6 says that a mediator may also attend. Now, in my experience, that is much more rare, but it is interesting to know that they can. The practice direction also sets out the specific documentation that we should have. So certainly for any solicitors when preparing bundles, and that's something we'll touch on briefly later, those are the documents that we want to be seeing there: the application, the C1A, and the notice of hearing, any response, and the safeguarding letter. And again, that's something I'll touch on briefly. Thinking about what we're actually trying to achieve at the FHDRA, there is one point within the practice direction that I want to read out. It's paragraph 14.11, and it sets out pretty clearly there what we're trying to achieve at that hearing. So it says, at the FHDRA, the judge working with the CAFCAS officer will seek to assist the parties in conciliation and in resolution of all or any of the issues between them. Any remaining issues will be identified. The CAFCAS officer will advise the court of any recommended means of resolving such issues, and directions will be given for the future resolution of such issues. At all times, the decisions of the court and the work of the CAFCAS officer will be taken account of any risk or safeguarding issues that have been identified. So that's it. That is what we are dealing with broadly at a FHDRA, and I think it's useful always coming back to that in preparation. So a few typical issues that arise at these hearings. Safeguarding, first and foremost. So this is touched upon paragraph 14.3 of the practice direction. And a couple of points to, well, you should be familiar that CAFCAS will speak to the parties. They will produce a letter setting out any safeguarding concerns. Paragraph 14.3a says that the court is to disclose the content of the safeguarding letter unless it considers to do so would create a risk of harm to a party or child. Now, in my experience, that's reasonably rare, but that can happen, and that can be really tricky when you're effectively going in blind to these hearings. One of the big points in relation to the safeguarding letter is that there is always a risk of an adjournment. There is usually an adjournment if we don't have that safeguarding letter. And indeed, it's paragraph 14.3d says that if the safeguarding information is not available at the FHDRA, the court should adjourn the application until the safeguarding checks are available, and interim orders should not be made in the absence of safeguarding checks, although it does give the caveat, unless to protect the safety of the child. So we want that safeguarding letter there. There's little we can do without it, and that's worth chasing up on before the hearing. Another key issue is allocation. So the case should have been allocated shortly after issue, typically in the gatekeeping order. That decision will be considered again at the FHDRA. It will be considered in line with the President's guidance on allocation, and the crucial factors to consider from paragraph 7 of that guidance I've put on screen. Really the one that it typically comes down to is complexity at subparagraph E there. And in my experience, where this tends to be an issue is if a case has been allocated to magistrates, but then serious allegations are made. And typically that's when then serious allegations are made by the respondent, perhaps after the allocation decision has been made. And magistrates will tend to reallocate that to a district judge. And it's worth flagging in preparation for the hearing if we think that may be an issue, because we need to think, what can we achieve at this hearing if we are going to reallocate? So what a magistrate won't do is say, look, let's reallocate this to a district judge, and in the meantime, have the interim contact your order you're after. They won't make those sort of major decisions, but we can get some directions to move the case forward. Some directions, I say, which can be helpful. So have a think about what we can do to make the hearing as worthwhile as possible in those situations. Reports are a big issue for Hudras, so we need to consider whether there are welfare issues or other specific considerations which should be addressed in a report. And the typical ones, of course, will be a Section 7 report. A Section 37 investigation may also be required, and typically clients, of course, in private client matters will not want that to happen. That's where the local authority considers if it's necessary for them to commence care proceedings and take an investigation into that. And so worth bearing in mind if there are very serious allegations on both sides, if that's something that needs to be borne in mind. And indeed, if there's any expert evidence that we need, the FHDRA is the time to flag that. And if we can get orders for that from the outset, that's very helpful. Other directions that we are typically concerned with, and which we want to flag up, for instance, in our position statements that make it absolutely clear to the judge that we're after. Ultimately, what the practice direction says, this is a quote from paragraph 14.3, we're looking for the directions required to ensure the application is ready for a DRA or a final hearing. So quite simply, it's what information do we need and how do we get it is how I like to look at it. And I've put on screen some of the typical directions that you will be familiar with. So statements, we may need drug and alcohol testing. Police disclosure. So if we need that, we need to think about which police force we want that disclosure from and the dates and so on. Whether to list a fact-finding hearing, I'm going to come back to that. Interim contact, Andrea's got to deal with. And we always need to list a future hearing. And in doing that, it's worth thinking about any steps that we need to put in place for that hearing, for instance, special measures. So I said I would come back to fact-finding hearings. Now, whether to list a fact-finding hearing is a full webinar in itself. And indeed, helpfully, there is a full webinar on that on 42BR's website. That was by Alison Pryor and Mark Challoner. And I will refer you there for all your fact-finding needs. And I've just put a summary on screen. So practice direction 12J, paragraphs 16 and 17, those are the key paragraphs that we are considering in terms of listing a fact-finding hearing and whether to do that. And again, I've put on screen there the key section from REHN, with which you may well be familiar, and that provides a really helpful summary. And effectively, the court is looking at whether there is a sufficient factual basis upon which to conduct a welfare analysis. And if there isn't, and we need to establish the facts, then that's something that we may be able to order at a FHDRA, but it may be that we need to get some information first and come back for another hearing before then. And if we do list a fact-finding hearing, and indeed, if that is up for grabs, if one party wants to, or it is an issue before the court, it's always worth bearing in mind the counterfactual, effectively. What directions do we want if we are listing a fact-finding hearing? On the other hand, what directions do we want if we aren't? And so practice direction 12J, this is if we are listening, sets out the considerations, and that's paragraph 19. So we want to sort the key facts in dispute. We may want Scott schedules, and the court tends to be a bit less hot on them these days, in my experience. And we need to consider the evidence that we need, statements. Do we need a third-party disclosure or third-party statements as well? One thing that's really worth bearing in mind when listing a fact-finding hearing is how that hearing will look, what the structure of it is, and crucially in relation to cross-examination. And this is where you're dealing with a litigant in person. There is a prohibition on the alleged perpetrator of domestic abuse cross-examining the alleged victim. And so a QLR may need, a qualified legal representative may need to be appointed. And so we may need directions for that. And it's always helpful to have directions in terms of a contingency for if one can't be appointed. And that's typically the litigant in person's questions being sent to the judge effectively screening them and then asking them on their behalf. That is something that typically we come back to at a PTR, and I'll deal with that very shortly. The one other point I've just flagged is from paragraph 20 of practice direction 12J, and that is that we must fix a DRA to follow the fact-finding hearing. So briefly, pre-trial reviews, as I said, it may be that we need to consider a QLR at that stage. And ultimately, PTRs are about considering, are we ready for trial? Have the directions been complied with? Do we have the evidence that we need? And it may be that there will be directions for a schedule of allegations before the PTR, and then the judge will come to a view at the PTR which are going to be pursued and which are going to be litigated at the fact-finding hearing. And we will also deal with witnesses. So it may be that third-party witness statements have been filed, and we will consider whether there is permission for those witnesses to give oral evidence and for those statements to be relied upon. And then a witness template is also something that we want to consider for the fact-finding hearing. So worth bearing all these in mind going into a PTR. The final sort of hearing that I want to discuss is a dispute resolution appointment. So that can typically take place following a Section 7 report coming back. And ultimately, at a DRA, we want to consider what information do we have, what information does the court need, and how do we plug that gap through the making of directions. So if we have had a Section 7 report, that author may attend. In my experience, it's not frequent that they do at a DRA, rather at a final hearing, and they will only attend if they are directed. And what the court will do, this is paragraph 19.3 of Practice Direction 12B, for identifying the issues, considering for use the DRA as a final hearing, resolving or narrowing the issues by hearing evidence. Now, I want to put a pin in that. I'm going to address that next. Then identifying the evidence to be heard on the issues which remain to be resolved at the final hearing, and giving final case management directions. What I haven't included is paragraph 19.3(5)(a) to E, so it sets out there examples of those case management directions. Now, I said I would come back to 19.3(3). So what that says is that at the DRA, the court will resolve or narrow the issues by hearing evidence. Well, that sounds quite a lot like a final hearing, and that does cause confusion in my experience. And typically, I've seen that relied upon where you've got a Section 7 report, it's clearly in one party's favour. That party says, well, let's wrap things up on the basis of that report and get a final order today. And in fairness, on reading that subparagraph, you may think that that is possible. But there is case law which says that that should not be done if one party does not want the proceedings to conclude at the DRA. And that is typically because they disagree with the findings of the Section 7 report and they want to pursue that through and challenge it at a final hearing. So the case I've put on screen is P&F. That was an appeal before the Honourable Mr. Justice MacDonald. To give a broad overview of the facts, it was appeal against a final child arrangements order, which provided for indirect contact only between a father and his 11-year-old twins. This was an order which was made at a DRA. The broader background, the father had historic convictions and a restraining order preventing him from contacting the mother. The Section 7 report said there should only be indirect contact, and that was in line with the wishes of the children. There was a DRA. The father was a litigant in person at that DRA. He disagreed, as I say, with the findings and recommendations within the Section 7 report. However, a final order was made. The recital to that final order said that the father vacillated, but ultimately elected not to proceed to trial. On an appeal, they found that wasn't quite accurate. In fact, he did not consent to a final order being made. It was effectively imposed on him at the DRA. And what they held, I've put the relevant paragraph up. It's paragraph 42, and it's on the slide. And that is saying there that where there is a dispute at DRA, the court should assist the parties with a frank evaluation of the evidence, but this cannot extend, and this is the text in bold, this cannot extend to making final orders where it is clear that a party continues to contest the matter and to seek a different outcome. And indeed, it went on in the following paragraph to say that to do so would be a breach of Article 8 and of Article 6 of the ECHR. So it's a useful case to have up your sleeve if you're contesting the recommendations of the Section 7 report at a DRA. It's a case I've relied on quite a few times, and I find that it does tend to be really quite relevant at lots of DRS. So there we go. That is what I have to say on the various case management hearings that we typically encounter. I'm going to hand it over to Andréa now, and then we'll have a bit of a chat at the end about some practical tips that we have for you.
Thank you, Max. So we've heard about the different hearings and their purposes and how to navigate them. What everyone will be aware of is that with children proceedings, they can take quite a long time, often months, but usually longer. And we are sometimes looking at years with the parties in proceedings. What that means is that interim contact is an issue that will be raised, usually from the outset, and will be relevant to most of those hearings. So when looking at interim contact, Max touched on Practice Direction 12J, which is again key and a key consideration of the court when looking at interim contact in cases where there are allegations of domestic abuse. What the court will be looking at is whether any interim contact can safely happen. And what that will usually be informed by is the safeguarding letter, which again, Max touched on, that is usually prepared by CAFCAS or the local authority at a FHEDRA stage. In the safeguarding letter, there would usually be an indication about whether the professionals consider that interim contact can safely happen, or whether it may need to be an issue that is considered following a fact-finding or a welfare analysis. On that basis, the court is likely to take a cautious approach when considering the issue of interim contact. What that would look like is that the court may say that without a fact-finding and an agreed factual matrix, that they won't be considering the issue of interim contact, or it would be a matter that's reviewed either following the fact-finding or the Section 7 report. In terms of the court's approach and the considerations that they will have, that will include the professionals' views. So again, that's CAFCAS, that's the local authority in some cases, sometimes the children's schools, GP, or any other disclosure that is available to the court at the time when they're being asked to make the decision. Another consideration that they will have is the length of time that has passed since the non-resident parent has had contact with the children. So in some cases where proceedings are issued quite soon after contact breaks down, the court might say that the status quo is for that non-resident parent to see the child, and then that should continue. But in some other cases where it's been some years or quite a significant period of time out of the child's life without contact, the court is likely to say that this will need to be a finely balanced exercise and that we need to address it in a child-focused, sensitive and gradual way. And that's likely to then push the issue down to, and like I said, either after the fact-finding or after a Section 7 welfare analysis. In some cases, there might be some indication given by the child about whether or not they want to have contact with their parent, whether that's through direct work that they've done with professionals, or sometimes the children write to the court with their wishes and feelings. And that might be another part of the court's consideration when looking at whether interim contact is appropriate and whether it is safe. I've then written about getting creative. So there are circumstances in which the court says that interim contact is not appropriate and it's not safe, but the court is often looking at direct contact, and that's at contact centres in the community or at the non-resident's parent's home. However, sometimes the best thing to do is to try to get some form of contact going, even if that's indirect. And a good place to start is usually by letters or cards, and you can invite the court to record that the child is not under any obligation to respond, but that allows the non-resident parent to be reintroduced, to send the child lovely messages, to be in the child's mind, even if they can't physically see the child. Similarly, there's photos, there's gifts. When it comes to Christmas time, there's a lot of issues about the non-resident parent wanting to just be able to get a gift across to the child. And that's a good time to raise a matter of indirect contact in the interim. It's also just worth noting that just because the court does not endorse or direct for interim contact doesn't mean that it cannot be arranged by agreement. So the parties are well within their rights to exercise their parental responsibility. And if they are able, through their solicitors or through a third party, to agree on some form of interim contact, that can be done outside of court and does not need to be endorsed by the court. But again, it is about ensuring that it can be done in a safe way for the children. So moving on now to appeals. So the Family Procedure Rules, Part 30, deals with appeals. And what we're looking at specifically is the process of appealing case management decisions. So that is all of the hearings that Max took us through, and basically includes any hearing except for the final welfare hearing where final orders are made. So Rule 30.4 of the Family Procedure Rules sets out the time limits for filing notice to appeal to the court. So that notice will need to be sent to the court that made the decision, and that will need to be done within 7 days of the decision. So for example, if a case management decision was made today, you would need to appeal or file a notice to appeal within 7 days, so by next Thursday. You will then have a further 14 days to file a more detailed grounds of appeal or a skeleton argument, which you can flag in the notice. So the notice needs to be in within 7 days. The more detailed legal arguments can come in 14 days thereafter. So you have a total of 21 days from the decision being made to the deadline to provide a full appeal. In terms of the notice of appeal, what that should include is a brief introduction setting out the parties, what the hearing was, who the judge was, and what case management decision is being appealed. Usually, you would use the notice of appeal to set out the ground of appeal that you are seeking to rely on. For case management decisions, usually the ground that would come up is procedural irregularity or procedural unfairness. And examples of that would be, for example, if you felt that a judge had made a premature determination of facts, whether insufficient weight had been given to pertinent material, whether the issues had been narrowed in a way that you considered to be unfair to your client's position. So there are lots of different ways that you can plead the ground of procedural irregularity or unfairness. But you would set that out very briefly in the notice of appeal, and then you would then use your skeleton argument to get into the kind of the crux of your arguments. That's when you would want to get into your legal arguments, relying on case law and persuading the court that this case management decision needs to be looked at again. When looking at case management decisions, because family proceedings will be ongoing, it's likely that the appeal and the next hearing might clash in terms of dates. So when you look at Practice Direction 30A of the Family Procedure Rules, subparagraph 4.5a, that sets out what the factors that the court would consider. So those include whether the issue is of sufficient significance to justify an appeal, the procedural consequences of the appeal, so for example, the impact on the timetable, and whether the procedural consequences outweigh the significance of the case management decision. And finally, the court will also consider whether it would be more convenient to adjourn the determination of this issue. So in children proceedings, delay is a big consideration of the court, and as Max set out, it can often be seen as prejudicial if there is significant delay, and it's usually found not to be in the children's welfare interests to be in lengthy, protracted proceedings. What this means is that there is a high chance that case management decisions, case management appeals will be dismissed. However, that doesn't mean that you should give up, because the court does have a duty to actively case manage, and that duty includes revisiting issues if they are raised again. So using a fact-finding hearing as an example, there's often times where the court looks at whether a fact-finding is needed at the early stages of the proceedings, so for example at the Fahedra, and decides that it's not necessary. But if in the course of proceedings further information comes to light and the court decides that actually, or one of the parties decides to raise it again, the court does have a duty to consider that afresh with the new information. And it may be that even though an appeal at the time of the Fahedra would not have changed anything, that can be raised later and dealt with in that way. So just because a case management decision appeal isn't granted doesn't mean that issue cannot be revisited. And I think that's the positive thing when looking at case management hearings. They are an opportunity to raise important things, particularly in cases where it might be a different judge. There might be further information that wasn't available at the time of the last hearing. So there is a duty for those things to be considered properly and finely balanced at each and every hearing. So we're now going to move on to some practical tips. These are aimed mainly at those of you who are solicitors, but they are also helpful to barristers. So starting with briefs and what briefs should include. So a brief to counsel is a very important document that actually is usually the first reference point for counsel when picking up a case. It seems obvious to say, but one of the main things and the first things that the brief should make clear is the parties, who the parties are and who counsel is acting for. So you'd be surprised by the amount of briefs that come in and you're not quite sure whether you're for the applicant or the respondent. So that's one thing to just set out clearly from the outset. It helps to know if the other side is represented, though I appreciate that's not always clear to those instructing either. It's also helpful to have, with prior permission, the client's telephone number so that on the day of the hearing, if anything goes wrong, you can give them a ring without needing to hound solicitors and email them on the morning of.
I think it can also be quite helpful, and I know lots of solicitors do this, to flick across our website profile to the clients beforehand. The amount of times I'm looking around at court for a client and they say, I recognise you off the website. And they sort of find us that way. That can be really quite helpful. Yes,
that definitely helps. And then in terms of what the substance of the brief should include is a background of the case, the relevant background, if there isn't a separate case summary. Usually it's good to have what the client is seeking, what they hope to achieve at the hearing, what was directed at the last hearing, if there was one, and whether those directions have been complied with. If not, it's usually helpful to know why or what is outstanding. And it's also a good place to raise any concerns that the client might have or any particular vulnerabilities that counsel should be aware of. For example, whether special measures are required in the hearing, whether there are any language barriers and an interpreter will be required, whether there are any cognitive difficulties, whether intermediaries will be in attendance at court. So those are things that would be helpful to have in the brief. I don't know if you want to add anything else about briefs.
I think, and we'll touch on this shortly, but in relation to managing a client's expectation, it's really helpful from our end to know what those expectations are. And so any conversations that they've been about that, or that there have been about that, please do include that in there because it's really helpful when we are trying to basically discuss with the client beforehand how things will go, and yeah, so we know what's coming effectively on that front. I will touch on bundles then. Very exciting stuff. Look, the key thing really for me on bundles is that they are compliant with any directions that there were about those in the last order. It's not typical that the order will say there must be this document in the bundle. But if that has been directed on the last occasion, well, then absolutely we need to make sure that that's in there. So that's worth having a think about. The other thing I would flag, and it's worth remembering, we're dealing with case management hearings here. There'll be a 1 hour hearing. It will be a judge with a very busy day, no doubt. And we don't want those bundles to be unduly long, because a judge will not read an unduly long bundle. And hopefully the judge will have read some documents before we go into court, but they will not have had the chance to read too many. So an 1,000-page bundle for a 1 hour case management hearing doesn't tend to go down too well with that judge, and doesn't tend to be terribly helpful if it can be avoided. So that's worth bearing in mind. In a similar vein, if a case summary and a chronology can be put in there, that tends to be really helpful. Streamline things, get the judge up to speed as quickly as possible, so we can make the best use of the limited time that we will inevitably have in court. So those are a few things to bear in mind just in terms of bundles and then being created for case management hearings.
Yes, and case summaries and chronologies are also very helpful to counsel when drafting our position statements, which is the next tip. So position statements are usually prepared by counsel, but there are also many instances in which instructing solicitors prepare those on behalf of the client. It's important for position statements to be concise and just clearly set out the relevant background in the case, any updates since the last hearing, whether that is factual or procedural, and to set out clearly and concisely what the client's position is and what they are inviting the court to do at that hearing. So I have had some position statements that are 16 pages long, and I don't think that gets it quite right. The idea of the position statement is to make it easy for the judge and for the court to look at this document very briefly, figure out what's happening and what this party wants and what they are inviting the court to do. Which leads me on to the importance of including any directions that are being sought into your position statement. So whether you're inviting the court to list the next hearing, list the fact finding, direct statements, direct various disclosures, whether that's from the police, GPs, schools. These are all things that you would want to set out in your position statement so that the court can have a think about those things before you go in. And it also helps to kind of target your pre-hearing discussions with the other side when you get to court, and you can quickly figure out whether or not you're going to agree on anything or whether you will need to address the court on everything. So I think that's as much as I have to say on position statements.
I think the only thing I would add to that, and it's just a very basic practical point, is to check and to recheck that the judge has actually seen your position statement. And so obviously file it on time, if possible, the day before. And if it can be emailed as well directly to the judge when the listing comes out, great. Check with the usher or the clerk that the judge has seen it when you arrive to court. And then it is always worth checking once you're in court, in my experience, Judge, have you seen my position statement before I continue? Because it has certainly happened to me a number of times where I've been told that it's made its way to the judge and then the judge hasn't in fact seen it. So always worth checking and double checking that. Next one, and we've foreshadowed this a bit, is managing clients' expectations. It's a really tricky point. To have difficult conversations with clients is difficult. And by no means are we just trying to offload that to our instructing solicitors, but it is really helpful if a client's expectations are managed before a hearing, and particularly in the likes of interim contact, and whether a fact find might be necessary, and the cost consequences that can have for clients and so on. They can typically have some very strong views about that, and that's entirely understandable because of the subject matter that we're dealing with. But it is certainly really helpful if a client's expectations can be managed, if they can know, look, it is unlikely at this stage that we will get interim contact, we will do what we can, but here are the reasons why it's unlikely. And that's something that we will obviously take up with the clients at court, and it needs to be managed as sensitively as possible. But I don't think it's helpful for clients to have unrealistic expectations at all going into hearings.
And just to bounce off of that, Max, I think it is helpful when more than one person says the same thing.
Absolutely.
So when the solicitors managed the client's expectations and said, we might not get this, the court might have these concerns, this is what could happen, and then they get to court and they hear the same thing from counsel, they're more likely to kind of prepare mentally for either eventuality. And if for whatever reason the hearing doesn't go the way they hoped, then at least there is a sense of kind of, I was told and I was warned, and I think there's less of a shock on their part.
100%, and because these are very, very difficult days for our clients, and the more we can help them through that, the better, and that's done by them. By things not coming as shock, exactly as you say.
Yeah.
And actually, one thing in relation to that, it's typically very helpful to have a conference with solicitors and counsel before the hearing, and that's another opportunity for us to set expectations at that stage. So that's all worth bearing in mind, and I think that's a really important point going into these case management hearings.
So the next point is about litigants in person. So, as everyone will know, there's been a lot of cuts in terms of family legal aid, which means that many people are now representing themselves in proceedings. There is usually a reluctance when one side is represented and the other side is unrepresented for the litigant in person to have discussions with counsel at court. I think it's really important, particularly on the side of barristers, to approach the litigants in person ahead of the hearing, introduce themselves, explain that whilst they are representing the other party, they also have a duty to the court and to manage the litigant in person's expectation as well, give a brief outline of what to expect in terms of the hearing, ensure that they have seen the position statement if one has been sent in. Sometimes they might not, just to make clear, this is our client's position. Do you agree? Do you not agree? And try to have some sort of conversations that, again, make it easier for the judge when we do go into court. You can say, we've had a chat, we agree to these things, but these issues remain. And it's a good way, I think, also to ensure fairness, because it's obviously a very tricky system to navigate when you don't have any legal representation. And it's also important for them to know that whilst you are representing your client, there is a duty to the court. So, for example, when the court then asks counsel to draft the order, they know that that is being done on behalf of the court and not on behalf of their client. And you're not going to try to put in things that the court did not direct. And so I think it's very similar to managing clients' expectations. It's also managing litigants in person, ensuring that they understand the process, that there is transparency, and that they can see that whilst you have a double duty, both to the court and to your client, and that you are going to try and assist the court as much as possible in a way that doesn't prejudice your client's case.
And Andréa touched on orders there, and that's our final point. So, look, we all know that we need to draft orders following a hearing. It is very helpful if we can draft orders before a hearing, at least have a structure there, to clarify our thoughts in terms of what we are trying to achieve at the hearing. In my experience, it can also be quite a persuasive document. If you turn up to court and say, this is what we want, and here's it ready to go in an order, it's really helpful for negotiating with the other side. It can be really helpful for persuading a judge. And if you make things as simple as possible, in my experience, you are more likely to get what you want. So if you can, arriving with a draft order is certainly very helpful. In terms of what is being put in the order, it's really important to make sure that everything is dealt with, as much as possible is dealt with in court. And think about everything you need. And again, that's why drafting beforehand can be really helpful, if at all possible. Think about everything you want to include in there. because I suspect we've all been in situations where following hearings, we end up in what feels like endless negotiation about the draft order. It can lead to delays, which is not good for anyone involved, and the judges aren't typically too impressed. Delays in actually getting those orders to the judge. So we want to avoid that as much as possible. And the way to avoid that is for the judge to effectively make those directions in court and approve the directions you're asking them to make. So that, I think, wraps up our practical tips. We have had a question come through, which I will read out. It's something I must say I think we need a little bit more information on. So what I would invite that questioner to do is send the question through to events@42br.com. And indeed, if anyone has any other questions, please do that as well. What it says was, my colleague was told at court by the clerk that no interim contact would be ordered unless the parties agreed with the CAFCAS suggestion of 4 weeks of telephone contact and then further contact. Father wanted less telephone contact, so no contact was ordered. This can't be right. The questioner asks, and I share that feeling. That doesn't seem like it can be right. The court is not bound by CAFCAS's suggestion. I must say, I don't know whether that suggestion, however, came in a safeguarding letter or indeed in the Section 7 reports. That's something perhaps if we get a bit more information on, we could have a chat about. And I think that's probably as far as we can take it for now. I don't think any other questions have come through. And indeed, as I said at the start, it's 30 degrees outside. So I hope you're all watching from the comfort of your garden or poolside, if you can be. So we'll not keep things going any longer, but thank you sincerely for attending. As I say, please do send any questions you may have through to events@42br.com. The recording of this webinar will be available shortly on our website and indeed on our YouTube channel. And we'd be grateful for any feedback that you may have. That brings our summer series of webinars to an end, but we are currently in the process of putting together an autumn-winter series, so do keep your eyes peeled for those. So thank you for attending and have a good evening.
Thank you.